est maintenant ouverte.
Okay, well, welcome to everyone to day 2 of the policy sessions. And today we're going to move to, well, I was going to give you a false statement to show we're dealing with misinformation, but I will give the right answer. We're dealing this morning with misinformation, disinformation, and the role of social media. So with no further ado, avec aucun autre introduction.
Without further ado, I'll give the floor to Wayne McKay. Professor McKay, is that right? And he will chair this session. Professor, thank you very much. Hello, good morning.
Commissioner just pointed out is Wayne McKay, and I'm the moderator for your session. And I have the unenviable task of keeping people within limits in spite of all the good things you have to say. So the panel will address the roles played by 3 different things in the course of this. Social media in its various forms, which we'll address first. Mis and disinformation, and I think malinformation is another term they've used. And thirdly, ideologically motivated violent extremism, and in particular, how all of these relate to the context of protests generally, and somewhat more specifically in the issues here. The diverse and impressive panel members to my left are, I'll just identify them, give them a very brief introduction. Dax D'Orazio, immediate left, the Skelton Clark Postdoctoral Fellow, Department of Political Science, Queen's University, and Research Affiliate Center for Constitutional Studies, University of Alberta. And then next to him, John Penny, Associate Professor, Osgoode Hall Law School, York University, and Research Fellow with the Citizens Lab at the University of Toronto. And then Emily Laidlaw, Canada Research Chair in Cybersecurity Law and Associate Professor, University of Calgary Law School. And Dave next to her, David Morin, UNESCO Co-Chair in Prevention of Radicalization and Violent Extremism, and full Professor of Faculty of Arts and Humanities at the University of Sherbrooke. And last but not least, Vivek Venkatesh, UNESCO Co-Chair in Prevention of Radicalism and Violent Extremism, who is also a full professor at the Faculty of Fine Arts at Concordia University. So that is our impressive expert panel. Just very quickly, I'm going to say a couple of words about process. Our objective as a panel is to explore these complex issues in a way that hopefully assists the Commission and the Commissioner, but also informs the broader public. And to pursue this, I will raise some general questions to explore and then call upon either specific panel members or sometimes open it up to the panel. For the benefit of translators and the record, each member should identify themselves, or actually mostly I will do that. I will call on you and do my best to remember to identify your names so you're on the record. We're also reminded of the competing needs to be succinct and fall within our time limits, but on the other hand, speak slowly in terms of kindness to the translators and the public record. And speaking for myself, that's something we all have to focus on. I will be, as moderator, occasionally intervene if I feel we've gone beyond the proposed times. So with those relatively minimal introductions, I'm ready to start off, unless anybody has any questions. All right, so the first topic is social media, and in particular its impact on protests and those kinds of things, and the kinds of broad questions that I have in mind to be addressed on that topic is how has social media changed public discourse? Stated very briefly. How has it impacted activism and protest? How has it impacted protests like the ones relevant to this commission? And perhaps one that not hadn't given a lot of thought to, but does it matter who is protesting in terms of what kind of social media they're listening to? So with those very broad questions, and there's lots of other things, I'll turn it over to Professor D'Orazio to start us off.
Thank you very much, Wayne, and pleasure to be here with you all for a very exciting conversation.
I want to get the conversation kicked off by speaking specifically about three major consequences of the advent of social media for public discourse, understood in a very broad sense, and also for possibilities for debate, dissent, and activism. So the first major consequence, I think, is it's fair to say that traditional gatekeepers of information can be bypassed. If we're understanding social media and communication historically for a moment, traditionally, information was filtered through very few hands. And every time we see a revolution in communication technology, we see some commensurate friction related to who controls the flow and circulation of information and also meaning. At the same time that we see the advent of social media, we also see some almost mutually reinforcing trends in the field of journalism, and some of that traditional circulation of information. I think it's fair to say that there is a crisis in journalism, not just in North America, but also around the world, where traditional outlets of information are struggling to keep the doors open. And there is also a waning of traditional forms of journalistic content. We also see a fracturing of audiences that consume information as well. And so the advent of social media doesn't take place in isolation from these other political economic changes in a journalistic field. There are costs and benefits with this advent of social media, and the huge one on this front, as it relates to traditional gatekeepers, is that we have potentially more access to accurate and also more valued information. That said, we also see potentialities for a greater influence of things like conspiracy, rumor, hate, and also propaganda. The second major consequence of social media is that the delivery and circulation of our messages is both instantaneous and global. And thinking historically again, our means of communication was traditionally conditioned by proximity to others with which to communicate, and also the type of technology that we would be able to use. Social media has completely shattered those that conditioning, and we're able to, at the touch of our fingertips, communicate with literally the whole world and also instantaneously. That led to what we might call techno-optimism, which was we could communicate with others across difference, and that would be a net positive for global society. We now, unfortunately, speak of digital detoxes, having a healthy distance between ourselves and digital spaces, about echo chambers being mostly privy to communication that confirms our own biases or beliefs. And so the friction or the cost and benefits on this front are that we have access to drastically more information, but that there are increased technical means of limiting and correcting falsehoods. They often spread much faster than truth might spread. Lastly, social media means that public discourse has arguably become more democratic and also accessible. Although we have these really lofty goals for what we could call the marketplace of ideas, it's typically the case that those with the deepest pockets have historically had the loudest voices. And social media allows average people to contribute very substantially to public discourse, to see themselves seen in public discourse, and also register contributions and also complaints. Our public discourse as well is already saturated with information that is persuasive in one way or another, or has some goal or idea already attached to it. And so social media has allowed individuals to eschew some of that purposeful information that's in the public sphere, and also create greater opportunities for dissent. The cost and benefit here is that social media often can lead to greater surveillance. In a sense, it's been a godsend for the state security apparatus in some ways. It also can lead to increases in social conformity and also social control. And so we see a tension between making public discourse more accessible while also having some pitfalls associated with that, including surveillance and control. Speaking very specifically about how and why social media was impactful in the convoy protest, we Emily very helpfully mentioned in her paper that social media was the central nervous system of the convoy. I would definitely reiterate that, and it's a nice way of describing how social media was integral. Social media is a way of creating and circulating meaning, and so before the convoy protest, some of the same messaging garnered momentum and public attention because of social media. It was a way of creating meaning, finding community, and building eventually momentum for a social and a political movement. It was also integral in mobilizing and organizing specific meetings and events. So it's a way of people finding themselves together in something very, very specific and tangible. It's also a way to publicize and, in another sense, memorialize specific events. It's a way of capturing reality and signaling solidarity by consuming meaning together. It's also a way to contest what you might describe as official sources and accounts, and also to shape public perception. So sometimes it's a way to go around what's considered the mainstream or the dominant forms of information in society. It was also integral to fundraising activities, so it wasn't passing around envelopes or hats to collect money. It left open fundraising to a large swath of individuals, even all over the world. It's also a way to monitor opposition, to do something akin to counterintelligence, and sometimes even target opponents, not speaking specifically of the convoy protest, although that could also be the case. But social media is a way to monitor those who might be in opposition to a specific movement or a specific idea. And lastly, we see social media used for real-time communication for coordination. So social media sites have communication modes often attached to them that are instantaneous, so people can text and coordinate with each other. They can also use encrypted radio chats as well, so social media is also impactful in real-time communication. I'll leave it there as an opener. I look forward to more discussion. Thank you.
First of all, congratulations coming in under time. I appreciate that. And I just had one additional thought just in the minute or so you have left.
Sure.
The question of who is in the protest, does that change what kind of social media they would have access to? Because it strikes me that many protests, including the convoy one, would have a variety of people, truckers, perhaps extremist groups, others. And does it make a difference who makes up the protest in terms of what kind of social media they're likely to use? And that's a big question. So if you want to pass to the other panelists at some point, you're welcome to do that too.
Sure, I can be very brief and then we can pass it along. I think perhaps a way to understand it is to think about it as layers. So some social media sites are more public facing than others. For instance, a Twitter or a Facebook or an Instagram, it is very public facing. It is about publicizing very broadly a specific message or an idea or a concept or an argument. But there are other layers of communication within different social media sites where you might have different levels of encryption, so that monitoring or surveilling is a bit more difficult. Only the participants can see the end-to-end of that communication method. And so that more, not necessarily surreptitious, but closely guarded form of communication or information sharing, I think forms different layers. You have a more public-facing layer, which is garnering support in memorializing, in conveying details that are comfortable to be shared publicly. And then you have more subsequent layers that are perhaps more closely guarded for the insiders of a movement, let's say.
Thank you very much. So moving to the next sub-issue here, the existing regulation of social media, or lack thereof, perhaps in some cases. And one perhaps a bit more focused question, the possible impact of increased restrictions on protest for particularly disadvantaged or marginalized groups in society, such as Indigenous people, as a kind of a flip side of that. So with that, I'll turn that over to Professor Penny to take the floor.
Thanks very much, Professor McKay. And I just wanted to say I'd like to thank Commissioner Rouleau and for the invitation to be a part of this conversation and join this distinguished panel as well. Thank you for the questions, Professor McKay. I think those are two really important questions in light of the issues before the Commission. So I'll speak of two sort of general categories of regulatory framework. The first being law and statutory forms of regulation, And within that broader category, I'll speak to some additional subcategories, different kinds of laws that apply to social media content. And I'll speak to also social media-based regulation, the kinds of measures and techniques and tactics that social media companies themselves employ to deal with challenges when it comes to social media content. So speaking first to law and statutory regulation, I would say, so this would cover any statutes and laws that govern social media content and related activities, so behavior and actors that are related to the generation of content and its moderation and editing and regulation on social media platforms and services, for example. I would say that the single most defining element of social media legal and regulatory frameworks in Canada is that there's no single general law or regulation that covers social media content in Canada. Instead, it really is a patchwork of different laws and regulations that apply to and regulate different aspects of social media content. So within that broader framework and that key defining feature of law and regulatory frameworks in Canada, I'll start with one sort of subcategory, that being intermediary laws. Now, why do we refer to these laws as intermediary laws? Well, the idea here is that social media companies are intermediaries. That is, they are links and connectors between users and who generate content, post and express on social media services, and the platforms or the services or the social media companies connect them with the audience for that content, those who consume the content itself. So generally, we talk to laws that create legal rules and duties in respect of content that's generated by users and how that is fed and conveyed to audiences and other users as well. Those are intermediary laws and rules, and a few examples of those in Canada. We have certain specific laws that cover, for example, copyrighted material, where there are very specific legal duties that social media platforms, and that's another term that I'll use during my remarks before the commission. The idea with the concept of a platform is something that today scholars and experts typically use to refer to more larger, more influential social media companies, Google, Twitter, Facebook, and others. And I think the term itself, you can think of it as conveying the fact that these platforms provide an amplification of certain voices. The same way a stage or a platform in the town square allows someone to speak to a broader audience and for their voice to be heard. That's in a way how we can think of these social media companies or social media platforms. They platform, they provide a way of amplifying voices and content generation. So there are copyright laws as one example of intermediary laws and liability, and with intermediary laws that create liabilities potentially for these social media companies and platforms, but they can at times avoid liability so long as they meet their duties. Copyright law is one example. Quebec also has a specific law that creates a safe harbor or legal protection from liability for social media platforms if they remove illegal or unlawful content once they have notice of it. When we move beyond these defined intermediary laws, there are also what I call sort of general statutory laws and rules that aren't specifically designed for social media platforms or intermediaries, but have implications for them and indirectly create legal duties that social media companies and platforms have to abide by. I think a great example of this would be defamation law. Right? So if a social media platform becomes aware of defamatory content that's been posted, they have notice of it, to avoid liability, then they have to remove that content. Another example is criminal law. So certain criminal law provisions, for example, if a court order is put in place where social media companies may have to remove certain kinds of unlawful content, be it child pornography, non-consensual intimate media that's been posted there without the consent of the victim, terrorist or hateful propaganda. Those are other examples of how criminal laws can apply to these platforms, creating similar legal duties. And then the third sort of category of laws in this context that impact maybe not social media content directly, but the activities around social media content, but also impacts the broader ecosphere. So user information and user data is critical. It fuels the business model that a lot of these social media platforms make money and they monetize user content. So privacy laws, data protection laws, these are another subcategory of laws and regulations and statutes that impact on content production to the extent that they create legal rules and duties around how people's information and data that are collected on these platforms can be used and shared and distributed. When there's restrictions on that data, then presumptively it would make use of that information more difficult to target users. So typically social media platforms will use information around user data, user information for targeted advertising to monetize people's activities on social media platforms. But when we look at disinformation and misinformation, user information and user data is also used to target particular users for influence in disinformation campaigns online and offline. So in Canada, we have a few examples of such laws, like the Personal Information Electronic Documents Act, PIPEDA, which creates rules around the collection, use, and sharing of personal information by organizations in Canada. Interestingly, however, there are loopholes in PIPEDA. For example, political parties are not constrained by it, and that's, I think, an important hole that needs to be addressed. And last, of course, but not least, there are social media-based regulations. And I use regulation in sort of the broader sense here. In this case, I'm referring to the rules and policies that social media platforms and companies themselves develop to deal with content and other issues on their platforms themselves. That can include content moderation policies, that can include privacy policies, and typically these kinds of measures are implemented through policies that are conveyed to users, but they're often enforced through the actual design and features of the platforms themselves. There can be human-based forms of social media content, regulation and moderation, but typically one that we'll be talking a lot in our comments today are algorithmic. So algorithms and technology are critical to have larger social media platforms deal with content and deal with offensive content. Typically in these cases, a lot of these measures are voluntary. As I said, there are not a lot of specific laws that create duties and obligations on behalf of these platforms to engage in social media content regulation and moderation, but they do so, often for business reasons. And because they do so for business reasons, when their business interests don't align with certain content moderation, often the measures that they take can be seen as ineffective. So that's a broader look at the landscape. I'll come to the final question that Professor McKay offered there, and I think it's an important one. There are, of course, many impacts of these kinds of increased regulation, and one impact in particular that my research has focused on in recent years is this notion of chilling effects. The idea that increased regulation, but also surveillance, both by government, law enforcement, and security agencies, but also by the platforms themselves. Right? In my research, I found that when users become aware of increased surveillance and data collection and data tracking, it can have a chilling effect. That is, a chill meaning it can have a deterrent effect on people's willingness to speak, engage, and share, both online and offline. And when it comes to more marginalized populations, my research has found that those groups are disproportionately impacted. And there's a number of reasons for that I can get into later. But as these groups who are already facing important barriers to participation in society, discrimination, racism, when you add on top of that concerns about targeted surveillance, targeted law enforcement action, you end up with a situation that groups who are already marginalized from the public, critical public and democratic discussion are further marginalized by these kinds of measures. At the same time, I should say, it's not a entirely simplistic view either. That is to say, increased regulation means a chilling effect. What I've also found in my research is that with carefully tailored laws, you can have laws that also facilitate greater participation in speech. Laws don't just deter behavior with threats of law, they also have expressive power. That is, laws convey values, they convey messages as to what a society views as valuable. And when a law is taken or enacted, it can send a message to certain marginalized groups that their speech and contributions are valued, and that can help facilitate speech. So I'll leave my comments there. Thank you.
Thank you very much. And the next issue we're going to, the last in the social media part, is what changes or improvements are perhaps under exploration and maybe about to happen to improve some of the gaps in the existing structure that Professor Penny just talked about. And Professor Laidlaw is going to take the lead on that.
Yeah, thank you, Professor McKay, and thank you for having me. Good morning, Commissioner Rouleau. So I co-chaired the expert panel with Pierre Trudel that for Heritage Canada back in the spring, and our mandate was not to come to some sort of consensus, but to have a conversation about what really should be the responsibilities of social media. And I had the pleasure of sitting on the panel with David Morin, who is with us today. And so we were not looking at what I would call the primary wrongdoers, which would be the individuals that are perhaps posting certain content online. We were more specifically looking at, okay, what are the roles of these platforms, or what John was just talking about is intermediary liability. And I think one of the most interesting things about our panel was, despite not having a mandate to reach consensus, we circled around and agreed on some of the, what I would call the core building blocks of what a law should look like for Canada. And I think that the first point I want to make is that we all concluded, I would say that social media or platforms should have what I would call a duty to act responsibly. Now, this was something that came out of the work of the Commission on Democratic Expression. And this is something that has been explored in other countries. We're seeing it with the Online Safety Bill in the UK, with their duty of care. It could be talked about as a due diligence model in the EU with the New Digital Services Act. It's a risk management obligations. And a duty to act responsibly, the way that kind of we were talking about it and the way that I think about it is that, it's almost product safety. That social media and other platforms should take care in the design of their spaces to be responsible, to protect their users from harm. It's not about perfection, but it's about turning their minds to how do their, recommender systems work? What content moderation policies do they have in place? What might be the unintended impact on this in particular groups? But it's not just about protection from harm. It also should be about protection of human rights, about the right to freedom of expression, about the right to privacy, to equality. one of the fears about imposing too strong or stringent obligations on social media is that it might incentivize them to put in place kind of just blunt tools, right? An automated tool that is going to remove any sort of content that might have the whiff of hate speech or any sort of extremism. But often hate speech is quite, the line between that and some more political views, what we would call expression that's core to democracy, that line between the two can be somewhat fine. So blunt automated tools are poor solutions. So if there's an obligation then to have a commitment to and realize the right to freedom of expression, then social media will have to think through, okay, what do we want to put in place that addresses maybe some of the risks of harm? Maybe we have a lot of children that use this space, but also, what kind of tools do we put in place that maybe aren't going to have an unintended impact on freedom of expression or end up being a system of surveillance? The other aspect that was key that we discussed was transparency. One of the issues that we have is that it's not easy to lift the lid to know how the algorithms work and how the decision making works for the various platforms on which we rely for discourse. And so almost kind of radical transparency is necessary. And that includes access by researchers and other civil society groups to how these companies kind of operate, and the algorithms is a form of accountability. This is something that's been implemented in the EU with the new Digital Services Act. The other thing that we circled around is the idea that we need a regulator. I mean, it is not realistic that that we go to courts to address many of these issues. Often these are high volume. They are low value, and the court process is really just too slow and inappropriate to be dealing with many of these issues. What we need is a regulator like a privacy commissioner, but with the power to impose fines that can audit the systems of these companies. It's about the systemic risk of the various social media. So they can investigate the companies, they can audit their behavior, they can help develop codes of practice, working with civil society, working with industry, and they can play an education role with the public. Now for some of the tougher issues. I think that, one of the challenges that Heritage Canada faces, and I'm sitting here just as interested as everyone else about what they're going to propose, would be scope. What's in and what's out. I mean, if we're realistically looking at creating a regulator, we can't impose all sorts of content and toxicity of everything that's out there on a regulator to investigate. Previously, they kept the scope quite narrow. Terrorist propaganda, hate propaganda, violent expression, intimate image abuse, child sexual abuse, and so on. And I think people quite rightly, including myself, said, but there's so much other types of toxicity out there that's unlawful that should be addressed. And but the issue is that the regulator has to start somewhere. So at least I've landed that there is a real justification, I think, for a regulator to maybe be more narrowly scoped at the beginning, and then it can build its capacity from there. Some of the other issues would be, should this cover, what platform should we cover? I've been using quite loose language here, saying social media and platforms, but we often talk about it as the internet stack. Are we just talking about social media at the top layer? Are we going down a level and we're looking at domain name registrars? Or we're looking at internet service providers? Are we looking at, companies like Cloudflare that provide cybersecurity protection and so on? I think this is quite a controversial area, but when we're thinking about it in terms of corporate responsibility, maybe their obligations should be different, but maybe there should be some responsibility there through legislation. The other is then mis, dis, and malinformation. It is one of, I guess, the existential threats that we face. And there is a real concern, though, in legislation that this could become almost the poison pill. Because as I get into, in the next section, we're going to talk a bit more about some of the legal issues, but I'll just, drop one point right now, which is there's quite a bit of content of mis and disinformation that is lawful, or it's that lawful but awful. So for the government to create legislation that targets lawful expression likely won't survive constitutional scrutiny. But it's a very different thing to say, look, a company needs to be responsible, much like safe cars, about, putting in place certain systems to manage risks. That has much clearer sense of I guess, constitutionality than saying, I, want social media to target lawful expression and take it down. That would not survive constitutional scrutiny. And I think the last point that I'll make now, well, I guess 2 points would be, one is a controversial point was recourse. The groups that are impacted by this need access to some form of remediation. And sometimes they get it through social media and sometimes they don't. And even if content moderation is in place, it doesn't always work very well. But the idea that every complaint about content could somehow be, pushed to some sort of recourse body is just not practical. It won't work. But victims need access to something. And so what that should look like, should it just be for intimate image abuse, child sexual abuse images? What should they have access to and what's realistic is a key point to discuss. And the last is size. And I think that what we saw with the convoy movement is that organizers and followers were all using all kinds of different social media. Some of them, major social media, what we'd say is quite entrenched, such as Twitter, and Facebook and YouTube and TikTok, but also some smaller alternative social media like I'd say BitChute, Rumble. Of course, there were conversations about Zello and Telegram, etc. So the EU has looked at, they've created risk management obligations just for very large platforms. And so that would be an obligation for companies to think through, how does my recommender system work? And is it actually having an impact that could, in a sense, undermine democracy? That sort of obligation would end up in Canada, if we put something in place, only targeting the YouTubes of the world or the Facebooks of the world, but similar obligations would not exist for some of the smaller platforms. And that's not going to work, because as we see, most of the users of social media use all kinds of different social media and are using some of these smaller platforms in social media to engage in these types of movements. So we have to think through with a type of law like this that, okay, targeting, very large platforms is perhaps misguided, but how do we then deal with the smaller and medium-sized companies that perhaps do not have the resources in place to deal with some of these issues?
I think that's a good point, perhaps, and I'm just realizing I haven't followed my own rule on whether I should introduce, say, Wayne McKay every time I do this, but anyway, Wayne McKay, moderator. To switch topics, staying with Professor Laidlaw, but move to the topic she's already touched on of misinformation and disinformation, with two fairly targeted kind of roles before we'll open it up to the panel for a broader discussion on this area. And that is the definition of the terms. And secondly, although you've touched on some of that, the regulation. So if you could start us off briefly on that, and then I'll open it up to the panel for the rest of this issue.
Yeah, thank you, Professor. So I'm going to give the definition that UNESCO uses for misdis and malinformation, but I do want to note up front that there's quite a bit of debate about what these terms mean. In particular for malinformation. So disinformation is the intentional spread of false information. So if you think a government-sponsored disinformation campaign. Misinformation is a bit different. So it is where information is intentionally spread and it's false information, but the person believes it to be true. And I think a large swath of what we see on social media, at least from individual users, is misinformation. So even if, say, a government launches a disinformation campaign, it eventually seeds to people who then believe it to be true and then spread it from there. The last would be malinformation, and this is the one where there's not a lot of consensus on what it means. I rely on UNESCO that defines it as information that's based on reality, but that's distorted. You know, it has that kernel of truth to it. But it does include that everything else bucket. And it can include potentially hate speech, harassment, trolling, doxing where private information is shared publicly, other forms of violent and extremist content. And, you know, one of the questions I was asked to think about to open up this discussion is, what is this in law? What laws regulate mis and disinformation? And what is the tension there with the right to freedom of expression? So I was just talking about laws that, you know, that are being explored to target social media. But the laws that target mis and disinformation would be targeting the individual users that are posting the particular information. And we do have a variety of laws that that target false information, but we do not have any law in Canada that broadly addresses or targets mis and disinformation, at least the way that we're contemplating here. So we have the crime of spreading false news, but that was held to be unconstitutional in the case of Zundel. And other crimes that target false information would be crimes of hate propaganda, counseling terrorism, fraud. And in civil law, and Jonathan touched on a few of these, defamation. Defamation is where, you know, someone sues another individual or entity for spreading false information that impacts their reputation. And perhaps also I would put in here the tort of false light. So that has just been introduced or adopted in Ontario. So it's just sort of a hodgepodge mix of different laws that apply to some aspects of mis and disinformation. One of the issues is that a great swath of this is what I call lawful but awful expression. It's hateful but not hate speech. It's extremist content. But it is not counseling terrorism. So it's not unlawful in the traditional sense. And also, as we were just talking about, the role of social media and pushing, you know, through advertising and recommender systems, it might be that lawful but hateful content ends up being pushed to users over and over. So in law, these are difficult areas to deal with. Under constitutional law, we have the right to freedom of expression. It is a broad right. It includes the right to seek, receive, and impart information and ideas. It includes the right to shock, offend, and disturb. And it also values false expression, in particular if it's information that's of public interest. So restrictions of it are supposed to be narrowly construed. And we face a hurdle in this area because what is truth, right? What is the perception of truth in one particular scenario? And I've listed a few laws where courts have willingly, you know, addressed what would be false information and consequences might flow from that. But much of what we're talking about on social media might be, you know, deeply held beliefs that are harmful, but it's difficult to pin down truth or not truth of it. Also, much of the dis and misinformation that's spread, when we can identify what's false, there's a lot more clarity to it. But some of it exploits what I would call the strategic ambiguity of it. They use humor. They use kind of the short, emotional memes with visuals or short videos that are known to be highly effective and impactful on users, and play on jokes and say, well, this is just a joke. This is just the gray area. This is really hard for law to address. And when disinformation has been criminalized in some countries, it has been used to target political opponents, dissidents. And so it's difficult to put in place these types of laws and generally don't comply with international human rights. So the last point I want to make here before we open it up is the other side of this. As much as I have mentioned the breadth and depth of the right to freedom of expression, I always think of the comment by the Supreme Court that freedom of expression is freedom governed by law. There are laws that constrain it, and rightfully so. And I think John made a key point that, laws help the right to freedom of expression of particular groups, marginalized and racialized groups that are impacted by what happens online. People are driven from participating online. They are dehumanized by these experiences of online, and therefore they don't get to enjoy the right to freedom of expression. There's also a growing body of work in the area of the right to freedom of opinion, and that the recommender systems and the advertising push to users is in fact infringing on the right to form an opinion free from manipulation. And this is something that is developing in international human rights and needs to be contended with here. I'd say that there's two things I want us to think about as we have a discussion here. Is one would be, what are the laws that apply to individuals, the ones that are posting the particular information and engaging in certain conduct that may or may not be lawful or falls into the category of the lawful but awful. And the other would be, what are the laws that then target social media and their responsibilities, whether it's through managing their advertising ecosystem, managing their recommender systems, algorithmic accountability, or their systems of content moderation.
Okay. Thank you very much. So we'll now open it up to the panel in a moment. Professor Laidlaw has already raised a couple of questions. There's a couple I will add among those that you can discuss. One is the scale of the problem, or how much harm is caused by misinformation and disinformation, is a broad question. And a second one, which was actually submitted, is the question of whether the definitions on misinformation, disinformation apply to the government as well as individuals, and if so, in what way? So with those kind of broad questions, I'll open it up to the panel, and if somebody just gives me a signal, I'll recognize you. Professor Morin.
Oui, merci beaucoup.
Thank you very much, Wayne and Mr. Commissioner. The interventions by my colleagues bring me to make two comments on the relationship, the complex relationship between using social media and the Ottawa events. In terms of crisis management, some would say public security crisis, others would say national security crisis. I think that was debated very broadly as to whether we are in a national security crisis or not. But this relationship is very complex. And the colleague D'Orazio, explained the impact of social media on the environment of a crisis such as the one that Ottawa experienced. And I would say there's a paradox here. Social media will allow us to collect a lot of information upstream from the protest movement and on the objectives, and it will allow us to know whether certain extremist groups talk about recreating 6th of January in Ottawa, as we saw in the Capitol in Washington, and it will allow us to know whether we are talking about the obligation to vaccinate people, or is it to block Ottawa and overthrow the government? So the social media gives us some visibility about the causes of the movement if information is well collected and well analyzed. Now, in the context of the movement itself, social media create some volatility. And Wayne, you asked a question earlier that what we saw with Ottawa was that there were a lot of people from very different political horizons who came to participate in this demonstration. People came with their children, their families, who were really challenging the sanitary measures, and others who had more extremist political agendas. And the social media allow this. They are like a menu in a restaurant. They put out all kinds of ideas online, and then individuals can appropriate some ideas and make their own menu out of that and participate in a common cause according to the various ideologies that are covered there. So the question of managing this crisis, there is some volatility because of the social media, because if the social media says we're 100,000 people in Ottawa, it's certain that that can create a snowball effect. So disinformation can have an impact. Dax mentioned this on operations, can use encrypted messaging to give each other messages about where we are, etc., to coordinate things. So it does have an impact on the management of these crises, and I think it's important to mention that. The second point on the question of regulations, and I'd like leave my colleagues to express themselves on that. But when these emergency measures were created 30 years ago, there was no social media at the time. And we're talking about a law here, talking about security where social media didn't exist. That's what we had. And if, for example, in a demonstration where you may have some violence happening, and I'm being careful here not to surpass my objectives here, but in the context of an emergency law, if we're in a volatile, unstable environment, we can use law on emergency measures in a preventive way. For example, if a province, and I can make a parallel with for example, an extreme climate crisis may force people to leave their homes before for example, the storm arrives. So the law allows you to take preventive measures. But in a volatile situation where there is a demonstration and all kinds of people participating in a movement, where the social media accelerate that movement, there may be special issues. So my second point is to say that for me, one of the shortcomings of this law is that these social media were not considered at the origin, and which complexified things because they didn't create the problem, whether it's propaganda or social protests. They didn't wait for social media to exist, of course, and in fact, social media are also positive. They allow for social progress. For example, the Arab Spring, the Me Too movement, and so forth. But my point was really on the question of managing social media in the management of a national security crisis in terms of the law that we have now in force. Thank you very much.
For the opportunity to intervene, and thanks also to the Commission and Commissioner Rouleau for this invitation. As a humanist, as a pedagogue, and also a multimedia artist who leverages various data points in social media to create different kinds of installations, I'm going to approach this question that's being asked from two perspectives. One is that I think we need to acknowledge that social media allows for pluralism, and that pluralism is essential in at least our determination of liberal democracy. What we're seeing, though, is a certain dehumanization of those who express what is commonly known as populist rhetoric. Right? And that's, I think, a pity in the way we've observed the characterization of those who have been participating in the convoy. Populism in and of itself is an important expression of liberal democracy. I think it's important for us to recognize that those who feel disenfranchised and those who feel that a hegemony of sorts, or in their definition, is imposing restriction on liberties or on certain equalities that they expect from their liberal democracies, those two major pillars, that they should be allowed to protest that particular imposition. Where social media, I think, has to be viewed beyond just the regulatory, beyond just the legal standpoint, and in collaboration, especially with big data companies, is in how conversations, discussions, dissensions, consensus building, however we want to see these, how those are manipulated through the software and through the algorithms that are being employed, developed, and in a certain sense, imposed on its users. I'll give you a specific example of this, and this is coming from a journal, and I printed out the abstract and the recommendations here. The September 2022 issue of Decision Support Systems, which speaks to this notion of coordinated, inauthentic behavior. And this is particularly important because through the use of chats and bots and various other software, we're seeing a version of what Shoshana Zuboff has called surveillance capitalism take on a much larger space in social media. What coordinated inauthentic behavior does is it takes on certain viewpoints. It assigns those viewpoints to what is known as either unexpected, suspicious, or exceptional similarity that you see amongst users. This basically means that you can create users that are not real, right? That are particularly virtual. And then you're able to create an outreach to a population that is subscribing to the echo chambers that Professor D'Orazio spoke about, thereby spreading a certain mis or disinformation or malinformation, as Professor Laidlaw defined for us. So in that particular case, there have been several reports by companies such as Meta, who are the parent organization of Facebook and Instagram. I believe Alphabet as well has released reports on how they've managed to curtail what they're calling coordinated inauthentic behavior. The Rohingya, the tragedy in Rohingya, the Stop the Steal campaign, various smaller but highly impactful anti-Semitic and racist discourses that have been propelled by such kind of software have actually been curtailed by tech companies. So one thing to think about is how can we learn from the ways in which technology companies are imposing regulation, and how can we also render those as transparent as possible? I'll stop there perhaps so that those who are dealing with this from a legal standpoint can debate this. But as a humanist, I think we're coming to a point where if we can't listen to one another without necessarily dehumanizing them, then we are at a threshold of being unable to deal with dissension.
Wayne McKay, moderator, just before we move to somebody else, I was struck by your term about coordinated inauthentic behavior. How do you describe inauthentic? It's kind of like that line between normal and abnormal. What's authentic and what's inauthentic?
Yeah, this is actually being debated, in fact, as we speak, about the liminal space in which those terms lie. I think the inauthenticity is reflecting specifically the fact that humans aren't propagating the information online, that these are being propagated by machines and machine algorithms.
Okay, great. All right, Moderator McKay, again, I open it up to any other comments. We have about 5 minutes or so left before we move to the next topic. Yes, Professor Laidlaw.
Yeah, thank you so much. And Vivek, I'm just thinking a bit about what you had to say, and it brought home, I think, one of the key aspects of what we're struggling with right now with freedom of expression, which is, social media, as Dax was saying, has opened up such huge opportunities for discourse and for everybody. And so we almost need to break down what the problem area is that should be regulated through law, what sort of we're okay with sort of leaving alone, right? And some of this is this commitment to the messiness of freedom of expression, to be able to discover and figure out who you are and hear other ideas. The struggle that we're having now is that because of the sheer volume and the kind of equitable access on social media, is that the opportunities to dehumanize and harm other individuals is made that much easier. So on a practical level, it's easier to cause harm and it creates a regulatory issue. But in thinking through what the role of law is here, we also have to think of what other things regulate. And so Twitter is a great example here, because at the moment, if we had a law in Canada, would it make a difference right now? Perhaps in my ideal world, it would set the standards of what we expect for corporate responsibility here, that Twitter has certain standards in place to deal with inauthentic behavior, to address content moderation, access to remedy for individuals. So that is where I think a law could help. But it's not as though Twitter, as I think Elon Musk has discovered, is somehow operating in a regulation-free zone. Because what? The marketers don't want to have to advertise on that platform. Well, then they're going to regulate a particular way. Do you know else who doesn't want it? Users. So users leave the platforms when they don't want this particular space. But also others further down. For example, the digital storefronts, the app stores right now are imposing conditions on Twitter to continue to carry the Twitter app. So there's all kinds of different mechanisms that are often at play when we talk about what regulates expression and what regulates what we say and do on social media.
Professor D'Orazio.
I'd like to pick up on some of the insightful comments from my colleagues and speak specifically for a moment about some of the practical and also moral tensions in drawing the lines of free expression in online spaces and specifically on social media. So the first one is practical, and that is built on millennia of histories of censorship. Censorship or content moderation, however you'd like to describe it, has several millennia of history, and there's always a tension between having restrictions or content moderation that is either too broad or too narrow. If restrictions are too broad, we can get chilling, for example. We constrict public discourse in ways that are unmerited, and that is a problem, not just for self-realization or the pursuit of truth, but democracy itself. Us being able to have something akin to a marketplace of ideas is a pillar of liberal democracy. On the other side, if our content moderation, if our restrictions are too narrow, they might be ineffective. They might only capture, for example, the outer margins of expression. And so the problem there is that they're not actually making our online spaces safe and accessible for everyone. And so that tension between regulations being either too broad or too narrow is seen throughout the history of censorship and also freedom of expression. The other thing, or the other tension, is practical, but also in a sense moral, and it is presently, because social media platforms for the most part are considered intermediaries or platforms rather than publishers, there's a disjuncture between the protections for expression citizens have in the public sphere, understood in a very big and broad sense, and the protections for expression that they have in online spaces. And so if we believe in free expression, if we think that it is the lifeblood of democracy, it may be the case that it is a problem that citizens have less protections for their expression on private platforms that are nonetheless have become the default public sphere. I think it is the case that people increasingly, if they want to be apprised of current or public affairs, are opening Facebook or Instagram rather than opening a newspaper or reading a periodical. And so that distinction between public and private on these platforms is really important and lurking below the surface of how we devise meaningful regulations related to content restrictions or potential content restrictions.
Okay. Professor Penny, we've got about 2 minutes left.
Sure, thanks. And I thought I'd pick up on a few nice comments from my colleagues here. When we talk about freedom of expression, speaking as a legal scholar, there are certain assumptions when we speak of freedom of expression as to why we see it as a key value, why we want to protect it and cultivate it in a democratic and free and democratic society. And, one of the assumptions of freedom of expression that lawyers often talk about is the idea of a marketplace of ideas, right? If you allow for people to engage with each other, that the best ideas in the end will rise to the top and win the day. But I think when we move to the new digital public sphere, as Professor D'Orazio has, that is, platforms are designed to favor certain kinds of speech, behavior, and activities. And often it's the kinds of activities and speech and behavior that they can monetize. And one of the unfortunate realities of the social media landscape is that often more harassing, polarizing, tribalistic, hateful engagement leads to additional polarization amongst different groups. It's that kind of engagement that these platforms often favor at the expense of more civil discussion and discourse. And so then I think that leads us also to the point that was also raised by Vivek earlier on, is this notion of surveillance capitalism. What are the business models that encourage and incentivize this kind of behavior, where this kind of activity and expression is favored, which drives, as Professor Laidlaw set out quite eloquently earlier, drives certain marginalized groups, women, visible minorities, more often targeted by this more antisocial behavior on platforms, which additionally skews the marketplace of ideas that we lawyers love to talk about.
Moderator McKay, again, excellent panel and discussion on this. We could go on much longer, but I want to move on to our next interesting topic, and we're pretty well on time at this point, which is the topic of ideologically motivated violent extremism, and in particular, the role that plays in society generally, and in particular in relation to protest, and just some of the broad questions to consider when Professor Morin kicks us off on this in a moment, is the source of that term, ideologically motivated violent extremism, some examples perhaps, and in particular its relevance to the issues at hand. So with that in mind, Professor Morin, the floor is yours.
Merci.
Thank you, Wayne. Yes, I'd like to take a few minutes to put the events of Ottawa in a larger context, in the evolution of ideological extremism, if I may. To start with, what happened in Ottawa was not an isolated event, for one thing, and we saw similar events in the preceding decade, and it was not due to the pandemic. The pandemic had an accelerating effect, that's for sure, because there was a lot of psychological distress, and there was and it encouraged the challenging of governmental authority. and it was used by other political agents as well. Now, there are three main things about this evolution of violent extremism, which I will link to the events in Ottawa. The first one is the emergence of a sort of convergence of the struggles, of the ideological struggles. Some say convergence, others will say confusion of ideological struggles. And the main element here is we try to design an ecosystem of violent extremism. You have the extreme right, you have the anti-government movements, you have the extreme left as well, and there's also the religious element. I'm thinking of jihadism here. And there's also the extremism motivated by hatred of women. That's where you have most victims. Think of the Polytechnique 30 years ago, the events in Toronto. There were two of them. Where you had many deaths, and that's what caused the greatest number of deaths in our country. So you have that ecosystem we're trying to design, and people will pick and choose, and they will construct their own radical menu. And for us researchers, it causes problems when we collect information and try to have clear boxes here. So that's where you have to contextualize the events in Ottawa. And there was the domination here of the radical right. You have neo-Nazism, neo-fascism, the extreme right, white supremacy, and all that. And there was also populism, right-wing populism that is gaining popularity in the West, and you have a reappropriation of the challenging movement. For 18 months, we observed some 60 or 50 conspiracy leaders, and half of them belonged to the right or the extreme right in Quebec and Canada. 20% belonged to the anti-authority movement, and 25% belonged to the alter science. So, alternative science. So we're trying to design this new environment, and you have multiple ideologies, but all that preceded the pandemic. And I'll get back to that question later. Now, second point, the challenge today is, yes, we have organized groups, but we also have a lot of solitary actors. I didn't say solitary wolves, because wolves are not solitary to begin with. And now we've been talking about social media. Now, all these people can exchange ideas on social media. They can feed on social media before they decide to act. Now, there's this figure from the Global Terrorism Database, and it says that almost 60% of terrorist acts were committed by solitary actors. And not by structured organizations. And that's extremely important, because one of the fears we had in Ottawa was this idea of a solitary actor who was feeding on online speeches before acting. And my third point, the forms of the violent extremism, and I'll give you three figures that are fundamental, and that's why we talk more about extremism and not terrorism. First you have hate crimes, and we've seen that here in Ottawa. And I'll give you some statistics here published by the Canadian government on that. In 2016, police services reported 1,400 crimes. In 2020, it was 2,700. So there was more hate crimes declared or reported by police. Now, this may be attributable to various factors, but because there's more reporting, but still, there is a very important increase. Now, this race, ethnic origin, sexual orientation, and race. These three categories allow me to think that they can all be linked to right-wing extremism. The second type, the terrorist acts, and again I'm quoting the database from 2014 to 2019, so before the pandemic, there was an increase of 250% of terrorist incidents linked to right-wing extremism in the West. So in Utøya, Anders Breivik in Norway, that opened a decade of right-wing terrorism in the West. The jihad threat did not disappear, but it created a new, or the resurrection of a form of right-wing extremism. So that's what we have now. And you have the, for instance, the incident of the mosque in Quebec and the one in London and Ontario too. It shows that we are impacted by right-wing extremism.
And my last point, the last kind of violence, has to do with violent protests. And once again, I'll quote you the Global Terrorism Database. Between 2011 and 2019, and it's interesting to look at the statistics before the pandemic, because we can clearly see that there were tendencies even then that have been exacerbated by the pandemic. So between 2011 and 2019, we see an increase of 278% of violent protests in the Western world. And we think of the yellow jerseys in France, which is a kind of a weird cocktail between extreme left and extreme right. And we also have the January 6th uprising in the United States, which was the pinnacle of violent protests, which is well documented. So the January 6th assault are all Trump sympathizers, but there were nevertheless extreme right groups that were involved in that incident, whether they were QAnon adepts or people who directly belong to groups like the Proud Boys, groups that are considered as terrorist groups by certain government officials. And of course, then we have the incidents in Ottawa with the convoy. So what I wanted to introduce here is that the events that occurred in Ottawa, and of course, I'm not going to compare the convoy with January 6th and the assault on the Capitol. There's no relationship. But the idea that I want to present here is that the violent protests with the involvement of underlying violent ideologies and extreme groups existed long before the pandemic. The pandemic probably exacerbated these problems and exacerbated the tendency of the rise of extreme right ideology in the Western world. And so I think it's really important to and Wayne still hasn't told me that my time is up, so but I will. You're getting close, yes. So Canada, and I will end on this point, even if the threat is less important in Canada than it is in the United States, the figures and the intelligence that we have shows that there is a clear and present danger. The question remains, has it been well assessed by the intelligence establishment of Canada? Has it been appropriately evaluated, and are we aware of the national security threat it poses?
Thank you. I'm just going to ask one question and either turn it over to Professor Venkatesh after that. Either one of you or both of you might be able to answer this. As you've probably noticed, lawyers are a bit obsessed with definitions. And one of the questions I have in the term itself, how does one define ideological in terms of the ideologically motivated violent extremism or even violence? Although I know that it could be a whole thing on that. So maybe I'll throw that out generally to both of you to comment on briefly. But Professor Moran, if you want to start off on that.
Oui, en fait, il n'y a pas vraiment de consensus sur la façon.
Well, there's no consensus as to the way we define this, but there are two elements here. First of all, there's a category of analysis that's a fairly broad analysis that allows us to recognize heinous crimes and terrorism, which are both recognized in the criminal code. And so so we just talked about terrorism, but now with defining this concept of ideologically motivated violent extremism, that we see that there's a much broader spectrum of violent crime. And so for us as researchers or for the security establishment, it gives us a broader picture of the problem. And then, so to answer your question about ideology, I don't think we have a consistent, and I don't want to open a debate here, but the security establishment look at ideology in a fairly restrictive sense. And because, of course, we don't want to enter into the political ramifications of it, because there are some ideologies that are religious and political, and some ideologies that profess one belief. So these are distinctions that are important, but in the context of the environment that I was describing earlier, these distinctions are rather gray or fuzzy. So I think we have to recognize on the question of genocide and apologies, I'm not a law professor, by the way. So that's what we understand by ideology.
Professor Venkatesh, on that or a much broader intervention.
Thank you. Yeah, so this is Vivek Venkatesh here. I just want to build on what my colleague Professor Morin pointed out as the government of Canada's distinction between ideologically motivated violent extremism and those that are religiously motivated and also politically motivated. But they also point out that it's very difficult to distinguish whether and how the three different types of violent extremism that have been defined interact and influence one another. And I think that's important to take into account whenever one creates policies, whenever one is debating laws that are being put in place in order to prevent this work. But my sense as a humanist, again, would be to decry the fact that the original meaning of ideology, which, if I'm not mistaken, is the science of ideas, has been reduced to one that describes perhaps fringe thoughts, fringe movements, fringe collections that have come together which are destructive in orientation. And I think that needs to be brought back to bear on how we name. So the nomenclature itself is important, but also how we treat this notion of ideologies. I'd like to just also build on some of the work that my team has conducted, and I want to acknowledge the work of my colleague and my former postdoctoral fellow, Ryan Scrivens, who conceived a really interesting study where he gained access to 10 former Canadian right-wing extremists. So these were in various neo-Nazi movements from anywhere from 6 months to more than 20 years. And over the course of 18 months, he and our team at Concordia University conducted life course narratives with these 8 men and 2 women. And I'd like to focus specifically on the role of the internet in facilitating right-wing extremism specifically. And what we found is not very dissimilar from what has already been described in other literature from the West, specifically in the United States, in that falling into the trap of neo-Nazism and right-wing extremism happens very much on a face-to-face basis. It goes through underground meetings, it goes through being groomed to a certain extent when you are young and feeling disenfranchised. And these are analyses that and themes that have come to bear with the interviews that we have looked at. But importantly, the internet was seen as a facilitator for entrenching these values. And this was done through forums. This was done through what Professor D'Orazio rightly labeled as silos or echo chambers, where you get patted on the back for points of view that resonate within a small and sometimes much larger circle of people who share a specific opinion of yours. But if you come back to my contention and the contention of big tech companies that coordinated inauthentic behaviors can in fact magnify these narratives to an exponential scale, then you can imagine how easy it is for someone who's falling into the extremist movements to be influenced very, very heavily by a narrative that is repeated over and over again. And the danger, I guess, that we face when we look at the specific events in Ottawa is if there are certain so-called fringe elements within the convoy and they are working the data that they are receiving on social media, the information they're receiving on social media, and some of which may be coordinated and inauthentic in its orientation, then there's a likelihood that they will want to act on the specific information, misinformation, disinformation that they're receiving. So the internet in and of itself plays what we're calling a secondary role. You do need a community, very often in right-wing extremist movements, to build a camaraderie, build a sense of belonging, build an identity with which you feel comfortable. And then you can find solace and find ways in which you can describe your own dehumanizing rhetoric towards the other, and then, unfortunately, act it out, right, through violent means. So I wanted to make this point particularly because this work has been is quite instrumental in the way that we are describing prevention programs that can help us to bring some of these former extremists or these extremists out of these movements.
Thank you very much, and Professor Laidlaw.
Yeah, thank you. I want to build on what Vivek is saying and maybe add a point about social media content moderation, because when we talk about violent extremism, I mean, we have particular laws that address, you know, counseling terrorism and hate propaganda, etc. But there isn't a law against extremism. And so we're often, you know, we are turning to social media right now to set down through content moderation, through self-regulation, what kind of expression they're willing to host or not. And so when we talk about some of the fringe platforms or social media, we're usually talking about social media that do not proactively monitor content to action and that just rely on legal definitions and only remove content that is unlawful. And so we're actually dependent on social media to proactively take some steps to address the forms of extremism that Vivek was talking about, is, you know, sort of entrenching different views. So let me give an example of how difficult this can be right now. I mean, one example I gave is just the use of jokes, but the other is that often groups talk in code. So let's imagine a video that is posted on TikTok and someone is saying some just, anti-government type message, which in and of itself is, I mean, there's nothing wrong with having that view and wanting to express it. But behind them are guns, for example, on the bed. And this is an example that's been given to me previously. What is social media supposed to do about that? I mean, some of this is that kind of the slow violence of just normalizing certain rhetoric and sometimes coded messages in the background. And social media is having to grapple right now with how to address this. This is lawful expression, but it might not be expression that they want to host in their space. But if we're talking about the private spaces as becoming the new public sphere, which is something that Dax was talking about, then they have to take seriously freedom of expression, but they are setting their own limits to address what is lawful, but extremism.
Moderator McKay, Professor D'Orazio, over to you.
Thank you. Hopefully, just 2 quick points. I think it's vitally important to build upon what's already been said, to take a peek behind the curtains and actually look at what motivates social media companies. So what the algorithms look like and what the infrastructure of those companies actually look like. The algorithm itself, or the architecture itself, essentially has 2 impulses. One impulse is to maximize engagement, and that is just keeping eyeballs on the apps, on the devices as much as possible, using any means necessary. In that broad sense, the content itself is a derivative problem of a much larger algorithmic problem, which is engagement is strategized at any cost, and sometimes to the detriment of the well-being of the actual users themselves. We're only now catching up to, in the public sphere, having an important conversation about the social, political, and psychological effects of social media engagement. We've talked at length about the positives and also some of the negatives, and so getting that balance right is very important. The business model, too, of some of big data is to ask for forgiveness rather than permission. And so they're often engaging in grand social experiments in commodifying the human experience and our own personal and private data for their own self-interest, sometimes completely surreptitiously, or at least on a contractual basis that can easily be questioned. Eventually, we have a very large public scandal that gives us a peek behind the curtains, like a Cambridge Analytica, like an Edward Snowden. But for the most part, people are blissfully unaware of the way that their experiences are commodified, repackaged, and sold when they engage on social media sites. The other thing that I'd like to mention is that when we're trying to understand the problem and the risks of extremism that's specifically online, in the sense that it comes about and it's nourished in online spaces, I think we need to make a really important distinction between the people that we might say are the useful ignorance, who, as a result of the pandemic especially, might be incredibly isolated, incredibly lonely. It's been a time in which we've had some social isolation and detachment. It's also true that in the last few decades, we could say that most people consume the mental equivalent of junk food. And so our informational literacy doesn't conform to some of these big lofty goals that we have for the citizen in the theory of liberal democracy. So we need to make a distinction between those who get swept up in these movements, these ideas, these arguments online, and those who actually pose some real legitimate danger to the public sphere. Those that are explicit manipulators, those that are motivated by sometimes very dangerous ideologies, and also those that are just shameless entrepreneurs at the end of the day. So again, making a distinction between those who might harbor some good faith and engage in online content, sometimes extremist content, say unknowingly in a sense, or at least out of a desire for creating meaning and also creating community, and those who are the propagators explicitly of misleading information for profit and also for ideology.
Moderator McKay again, Professor D'Orazio was just talking earlier about the echo chamber effect, and then I think Professor Venkatesh mentioned the sort of what I would call maybe fractured communities that are out there and people who get reinforced in their beliefs. And Professor Penny, you haven't had a chance to intervene yet, so I'll throw those two in your direction, and either of the other two can elaborate if we have moments to do that. So,
sure, thank you, Professor McKay. Professor Penny. I'm not sure if these comments are directly responsive to that question, but maybe in part. And I mean, some of this comes back to the broader regulatory challenges on these questions as well. Back in 2019, I was a visiting researcher at the Technology and Social Change Project at Harvard Kennedy School's Shorenstein Center, and we looked at what we called disinformation and media manipulation campaigns. The reason why we used the specific term campaign was these were examples of coordinated efforts to manipulate media and to spread disinformation. And in particular, we looked at a number of case studies, including some case studies of disinformation and media manipulation campaigns during the 2019 Canadian election. And building off a point that Professor Laidlaw made earlier, one of the challenges here is, we talk about surveillance capitalism, we talk about business models and the challenges with these platforms, and the business model that monetizes antisocial behavior, and that includes disinformation and misinformation, for example. But at the same time, the disinformation campaigns that we studied in 2019, a lot of the most successful ones were ones that had been seeded many years prior to 2019. These were stories and ideas and false stories, false rumors that percolated in far-right social media groups, whether we're talking on the Chans, 4chan and others, far-right nationalist groups on Reddit, for example, where they had been certain rumors and false stories were percolating for years. But once the election comes around, we have greater media coverage. There was a coordinated effort to use tactics, what we call working these false rumors up the chain, trying to get larger influential accounts and larger social media platforms to share this kind of information. And of course, there were even some successful disinformation campaigns where we had mainstream journalists asking questions of politicians about these rumors that had been already discredited and debunked by other journalists. But the broader point that I'm getting at here is that when we're thinking about how to deal with this from a legal, regulatory, even a societal perspective, we can talk about the large platforms, and that's really important, and the business models, and I've been also banging the table on that count. But we also, if we're going to be thinking through new ways or new regulatory frameworks, we also have to think about these more extreme marginal communities where a lot of these hateful content, disinformation campaigns are planned, coordinated, and conceived, and then later spread in critical moments like during elections, which mislead voters and have impacts that way.
All right. I think we're almost at the end, but Professor Moran, I'll take one final intervention here, and then we'll move on to the final stage.
Oui, merci.
Thank you very much. Two short comments. One of the major challenges that we have before the question of extremism is to draw the line between what is acceptable in terms of extremism and political violence. Most people agree that we have to be much more rigorous on the matter of apology of violence, of terrorism and so forth. And Emily, my co-chair, knows this. It's much more difficult when we talk about disinformation. When we talk about extremist ideas that underlie violence. For example, if we talk about the Great Replacement, whereby the theory that that we're trying to replace the original population of a country by a new population. But what do we do with that information in the social media? What is done with that? It's very difficult to draw that line for us. And the matter of disinformation is the same thing. How do you take on massive disinformation campaigns like Stop the Steal? What do we do about things like that? So that's my first point, is the question of the challenge. Do we accept collectively the extremists, and that we only don't accept violence in the name of extremism? It's important to accept that, like in a society, a humanist society like Vivek was describing, but if just because an idea doesn't call directly for violence, that it does not contain implicitly that call, and then racialist minorities are witness to that. My second comment is more on the matter of regulation. What we often observe is that the common point between all these extremist movements is the loss of confidence in our institutions. Not only that, but very much that. And the risk here is overreacting. In a country like Canada, extremism is still at a more or less acceptable level compared to the United States, for example. But I think overreacting could be counterproductive. And if in our societies we have legal instruments that are very, very restrictive, that will also reinforce this narrative of the extremists. And I think that is another challenge that we have to face as a society, to know where we draw the line. There's no magic formula, but we know that in societies where we tend to be too punitive, the security response just doesn't work in the medium and long term. So collectively, we have to question this. And I think that's what Vivek was mentioning as well, is when you listen to extremists, you have to listen to their grievances as well, to this society, whether it's social justice, lack of confidence in institutions, and so forth. And sorry, but I went a little bit beyond the matter of social media, but I needed to say that. Thank you.
Interesting and important, so I'm not concerned about that. I guess if we now are about to move, Moderator McKay here, to the final stage of this, which is an opportunity without interruption, unless you want interruption, to give your sort of thoughts and reflections on the complex issues presented to this panel, and then any advice or ideas that you might wish to suggest to the Commission or to the public more generally on these complicated issues. And maybe just in case we do run out of time, I want to say for myself personally, I thought it was an extremely interesting and diverse conversation on extremely important topics. So I compliment you all on that, and outstanding efforts to stay within the timeline. So I appreciate that. So what I will now suggest, and we'll just go around the table, I guess, in the order maybe the same as we started, with Professor D'Orazio first, just to your overall thoughts, reflections, conclusions on these complex topics, and any advice or suggestions that you might have. So over to Professor D'Orazio to start us off.
Thank you. Yes, indeed, a lot of generative conversation, so thanks to all my interlocutors. I want to pick up on something that was just mentioned by David that we hadn't quite mentioned yet, and that is that policy responses are always laden with unintended consequences. And if we're thinking about free expression specifically, that is definitely the case as well. One of the things that's notable with online extremism is that even though we might develop meaningful regulations, the speed and the pace of technological innovation means that policy and government, in a sense, is always sprinting to try to catch up. Extremists often get ditched from one platform and pop up on another, and it is definitely the case that we've not yet seen the full broad scale of what social media will actually look like. We will actually probably see within the next decade another complete rehauling or revolution in communication technology that facilitates new forms of engagement and meaning making and also extremism. Getting that balance right, and speaking again of those unintended consequences, we want to make sure that we are not completely driving extremism underground. There's also a case to be made that we want extremists out in the open, that it's much easier to contest extremism when it's out in the open and not lurking in the dark corners of the internet. We also want to be mindful that part of the impetus and the personal and also collective identity making that happens in extremist movements is based on this idea of being antithetical to the mainstream, of the dominant, of the normal. And so in a sense, being pushed to the margins is almost worn as a badge. It's a way to symbol authenticity and belonging. And I think the policy also needs to grapple with that paradox that if one's identity creation is based in opposition to the mainstream, policy shouldn't further that division. We need to think about shoring up trust in public institutions and also the public sphere. So again, a very difficult balance to be had. Speaking specifically and very quickly about social media regulations, I really think what needs to happen among policymakers and public intellectuals, among journalists, et cetera, is to think about social media in the framework of consumer protection. As I mentioned before, we're just now catching up to some of those ramifications, some of which are deeply personal about how social media is changing our social and political world. It's not the case that social media needs to be a punitive and venomous hellscape. It is possible to make the online space safe and accessible for everyone, to expand the public sphere, to improve it, to increase public participation and debate and deliberation at a time when trust and confidence in public institutions is waning, sometimes precipitously, or at least it seems. And so getting that balance just right is just important. And I appreciate conversations to that effect.
Okay. Moderator McKay here, and it's over to Professor Penny.
Great. And yeah, I'd like to again, just say it's been great to be part of this conversation with this excellent panel. Evelyn Douek is a professor at Stanford, and she has a line that she often uses in writing about content moderation. She says, everything is a content moderation problem. In ways, when you're thinking about misinformation and disinformation, I'm almost the opposite of thinking. That is to say, I think some things are a content moderation problem. When it comes to this particular challenge, disinformation and misinformation is a human behavioral problem. We've talked in this panel about coordinated inauthentic behavior, which is a critical important, that is certainly a key factor in this problem. Algorithms, a key part of this problem. But the reason why we keep seeing these disinformation campaigns and media manipulation and misinformation being shared at scale is that it works, that people are fooled. People have psychological biases. Professor Laidlaw nicely lays out in her paper some of the psychological foundations to the disinformation problem. That is, people have a confirmation bias. They look for information that confirm their own personal worldview. They have an identity affirming bias, looking for information and stories that they'd like to share with others that affirm their own cultural biases and worldview. And then on top of that is social psychology. The reality that we can speak as a society and how we want to promote freedom of expression and pluralism and these key broader mainstream values, but there are also these groups, extremist groups, ideological groups that exist on mainstream social media platforms that have an entirely different set of social norms, where trolling, harassment, spreading false stories and rumors about people is celebrated and encouraged rather than discouraged, the way we would see in broader society. So there's a human behavioral side to this. And I think if you go back to, the definitions that Professor Laidlaw set out nicely in the beginning, you can see the real challenge if we were to draft specific laws to deal with content. Because when it comes to distinguishing between disinformation and misinformation, it's a question of intent, where a person knowingly is spreading false content, as opposed to someone who's innocently doing so in good faith, but are doing so because they like the story and it confirms their prior assumptions about the target of the story, for example. And so you see the challenge from a regulatory and legal perspective of tailoring very specific laws that deals with specific content, which is why I would join in Professor Laidlaw's recommendation. I agree. I like the idea of a more generalized duty, a duty of these platforms and intermediaries to act responsibly. In the UK context, it's been proposed and described as a duty, a generalized duty of care. Why do I prefer that rather than having more specific laws in this count, or that specifically target certain kinds of content, although in some cases that will be necessary as well, because it closes gaps. It can encourage platforms to deal with more than just the bare minimum of lawful or offensive content, maybe dealing with some content that drives certain users from platforms, marginalized groups, visible minorities, women who are disproportionately targeted by abuse online. You can have that kind of a generalized duty that can also get these platforms to deal with misinformation, disinformation as well. A generalized duty also means that we don't have to tailor laws. Earlier, I talked about more obscure places online where more extremist communities percolate and seed false rumors and stories that later get picked up by broader actors and larger platforms, and in some cases mainstream media. The rules that you would tailor for those kinds of online contexts would be far different from the legal rules you would tailor for social media platforms. But if you have a more generalized duty that can be defined through over time, with certain regulations over time, more specific applications over time by courts, you can see how that can be applied both to the large-scale platforms, but also to those more obscure places online as well.
I guess we perhaps should move on. We're going to run out of time, but thank you. Yeah. Professor Laidlaw.
Thank you, Professor McKay. I'm sitting here listening to my colleagues, and there are just so many different angles to this. And I think one of the oft-repeated solution, which is, causes some to roll their eyes, but is because we all know it to be true, is that it's a multifaceted solution. If we really want to target the problems of dismiss and malinformation, we are looking at, education. We're looking at underlying social and economic factors. We're looking at improving laws in the area of social media regulation, which we've talked about a lot today, but it also might be in areas such as funding of media. And of course, we have a bill on the table examining that right now. I have been advocating strongly for a law specifically to address the responsibilities of platforms and social media specifically, and is this duty to act responsibly. We need this law, but it's not a solution to everything. It would be one piece of the pie. And I think one thing I want to emphasize with the few minutes I have here is that it's not a perfect solution, and it should not be a perfect solution. Working at its best is really about kind of lifting the game, in a sense, to just work in the direction of a healthier ecosystem. My fear is the be careful what you wish for aspect of this. And I think this is something that Vivek and David have been warning about, is the risks of over-regulation and kind of, I guess, too much intervention in some of these spaces. So it's really a question of how do we make this healthier? How do we make sure that everyone is welcome to participate in these spaces, and that social media are taking care to think through the impact of the design of their spaces, of the content moderation systems that they do or do not set in place, and the impact on users and on society? Well, it's not going to be a perfect solution to that. If it is operating appropriately, there is an error rate, right? But the assessment needs to be what then would be the bottom line of the expectation of these companies. One would be to have in place certain content moderation systems. One is algorithmic accountability, and I say that with some hesitation, and that would be to the extent that there is access to be able to review and hold them accountable for their algorithmic impact. And by accountability, I don't mean that it's outcome-based. Rather, what I would say is, can they then explain and justify the approach that they are taking to work towards a healthier ecosystem? And I think I might leave it there and pass it on to my colleagues and just say that, it's time, I think, as a solution that Canada introduces some sort of regulation here to start addressing some of the underlying issues.
Okay. Moderator McKay, over to Professor Morin.
Yes, thank you. What view to take on the events in Ottawa, with a bit of distance now? For me, the main information we can draw is that our democracy is strong and fragile at the same time. It's fragile because when some of our citizens no longer believe in democratic institutions, whether they be political, legal, media, scientific, then the rules of the game change.
Des polarisations sociales.
I think that we have this tendency to think that to take democracies for granted, whereas they are indeed very fragile. And I'd say that the Canadian democracy remains strong, and that's the message I want to send to those who protested in Ottawa. And the Rouleau Commission is a powerful exercise in democracy. We saw here 75 witnesses who talked about what they did and about the decision they took to put in place this Emergency Measures Act. And now, no matter what the Commission will conclude, the exercise of the Commission itself should convince us that our institutions are operating pretty well in a very transparent manner. And that's the strongest conclusion I can come to. And the second aspect of my observations here, now, it has nothing to do with institutions. It has to do with social convergence. How can we equip our democratic institutions with powerful tools powerful enough to defend themselves, but how can we reinforce the social dialogue? And this is a responsibility that we all have, not just the people around this table. And this the idea that, and I don't want to make a recommendation to the Commission, but we have to look at those events with certain empathy, but because we have to talk about the victims, because there were several here in Ottawa, but we have to talk about the grievances that people had when they came here to protest. Now, this has to deal more with political philosophy, But it's important to keep that in mind because this commission, to me, as a researcher, as a scholar, specialized in security, and as a humanist, as a Democrat, to me, this commission is a fascinating exercise in democracy, and that can contribute to cement the confidence of the population in our institutions. Thank you.
Turn it over to Professor Venkatesh to get the last word on this part. I just want to comment that I think that's a really important, they're all important points, but your point about the commission and the hearings themselves are a reaffirmation of democracy in Canada, and the fact that this kind of hearing is statutorily imposed in the Emergencies Act itself, I think is something we should take some pride in. So I like that. So Professor Venkatesh, last word on this part.
Merci. Alors, je vais juste prendre...
Thank you. I'd like to base my what I have to say on what Professor Laidlaw said and my colleague, Professor Morin, said. And I'm a teacher, and if I had suggestions for social media companies, for people in the political arena who help us strengthen our liberal democracy, I think our pedagogics should be, or our teachings should be much more social, something that will stay in schools and institutions, post-secondary institutions, I mean. And I mean by that that we must promote a thinking process that will help us humanize, as Mr. Morin says, to humanize the other, the one who's across from us and whom we don't see often enough in our online discussions or in person. And discussions often become tumultuous very much too quickly. So how can we have dialogue where we can leave our own echo chamber, our own silos, in order to listen to the other without necessarily reacting in when we are criticizing the other, when we forget to discuss a phenomenon that we're dealing with. I'd like to mention two people who influenced me very much. Chantal Leroux, she's Belgian. She works in Britain right now. She's a political scientist, and she talks about developing a pluralism that will be agonistic, not antagonistic. So how can we be comfortable in dissent? And that's something I'm trying to develop myself with the policies that we are developing around social media. I'm talking about regulation, but also our own behaviors in social media. Another thing, how can we develop an intellectual insecurity in our conversations? That's what Ian Callan from Stanford said. So this way we will be able to interrogate ourselves. We can have a civil dialogue by promoting frankness, and we would be promoting a sort of charity. Because when we don't agree with someone, we have to think and see where does that person come from? How did that person develop his or her opinion? And with that sort of interpretive charity, we could build a much more pluralistic framework, and this way dissension could lead to more consensus. And thank you. I want to thank you very much for allowing me to share this with you.
Much for all of that. Just on the last point, if I could ask one final question, a definition question, big surprise, which is agonistic, as opposed to antagonistic. I think I know what that means, and I quite like it, but I wondered if you just take a second to, Professor Venkatesh, just to give me a short statement of what that means.
Yep, I try and read Chantal Mouffe every week as much as possible, just to remember to listen before reacting. But I think their conception of agonism revolves around allowing for the possibility that you do not have to arrive at a consensus at every point in time and an agreement because of the dilution of the issue at stake. So an agonism will allow you to be very, very fiercely protective of your opinion, very fiercely protective of the rationale behind your opinion, but also at a certain point in time think, okay, there are different ways in which this particular issue is being preferred or offered to me because of the perspective of the other. That's how I see it.
Right. Thank you very much. Now, my understanding, and the Commissioner can correct me, we now take a break to solicit whatever questions may be submitted, and we'll return with some questions from Commission Counsel, if I understand that correctly, to the panel. And of course, the Commissioner can ask questions at any time. I don't know if you have any questions at this point, or?
Not at this point, no. Thank you.
Thanks. So I think I'm right. We're adjourned
Yes.
for now. Thank you.
We'll come back at noon.
The Commission is in recess for 30 minutes. La Commission est levée pour 30 minutes. The commission is reconvened. La commission reprend.